And we are live here on episode 3 of Baldani TV. Live from downtown Lexington is, as always, Bradley Clark, and I'm here with Abe Mashney. Let's go to the intro. All right, and we are back. And as you can see here, we now have a snazzy new intro, and we also have this Facebook like counter. So if you're out there watching, it would really appreciate it if you go to the Baldani Law Group page and you like us, because if you like us, this clock will turn up one by one. So we're trying to break 1,500 before the year ends. I know we can do it. Abe, you think we can beat 1,500?
Absolutely.
I think we can do 2,000, but we'll have to see. So today we're talking about frequently asked questions, and what I mean by that is questions that Abe has seen a lot of, questions that I've seen a lot of, questions that you all have out there. And what we're going to do is we've already got a list of questions, but if you have one that you want us to answer, put it in the comments. We'll go and we'll start answering it just as we go. This is going to be live. This is going to be interactive. This is why we built the studio, so we could give the people what they want. Isn't that right, Abe?
Yes, sir.
All right, so the first question that we're going to tackle today is one that came into us actually out of a friend from Chicago. And that question is, what happens after a person is arrested for a crime? And kind of talk about the process. So can you do that for us, Abe?
Sure. So ultimately, you're going to go to the police headquarters, and what you normally do there is they're going to interview you. If it's a serious crime or if they want more information, they will take you to police headquarters. They will put you in a room that's going to be recorded. They will ask you questions, and then ultimately they will transport you to the detention center. If it's a not so serious crime or they don't feel like they need to do an extensive interview process, then they will just take you straight to the detention center. At that time, you're going to go through the booking process.
No. Abe, these are really kind of questions that we're addressing most specifically how it works in Lexington. Not every jail is going to be the same, right? But they're mostly pretty similar.
Sure, yeah. So at least here, our system, you're going to at least go to the booking officer, where that booking officer is going to ask some background information. They want to know who they are housing at their facility. So they'll ask you about your name, your address, other identifying factors about you. And at that point, they're going to ask you about any type of medical issues that you have, because they need to know whether or not there's any conditions that they need to know about so they can try to keep you safe. Also, they're going to do the fingerprint, where they're going to get that identifying information. They're also going to check to see if you have any tattoos or identifying marks on your body.
Why would they care if you have a tattoo?
Well, if just for future purposes of investigations, if they have you, they're going to get as much information from you as possible so they could potentially identify you. And at that point, you are now in the system. And
Abe, do you have any tattoos you want to show the viewers at home?
Not at this time, no.
We're not going to.
I don't have any tattoos.
We're not going to show them our Baldani Law Group tattoos.
No.
We do not have Baldani Law Group tattoos. You can ask my doctor. All right, Abe, continue.
So the next step in the process is going to be the pretrial interview, and usually, at least here in Lexington, there's someone from the pretrial office that's going to be on call at the jail that is going to interview. They're going to ask you where you work. They're going to ask you if you have any emergency contacts. They are also going to take some background information from you, and they are going to complete what's called an NCIC, and that's a criminal background from all states, and that's going to go along in their pretrial report. And ultimately, they're going to have a pretrial assessment, and that assessment is going to list your risk factors to reoffend, and also a risk factor for you to failure to appear. And that's going to be given to the judge, and that information is going to be used to ultimately for the on-call district court judge to give you a bond.
Okay, great. Is there anything else you think that we need to know about this particular process, Abe?
So if you don't bond out, you will have your arraignment scheduled, and that should be within about 48 hours. Usually it's the next day, at least here in Lexington. And while your case is ongoing, you're also going to go to a third step, and that's going to be the classification portion of it, where they want to know if you have beef with anybody else in the jail, or if you're a gang member, They will classify you to, if you're a violent offender, or if you're charged with a violent offense, they're going to house you with other violent offenders. And so it's their internal system to at least try to keep people safe.
Okay, great. That's great. So I guess the next question, are you done pretty much answering that one?
Done.
Let's move on to, I guess, question number 2. And this one came out of an email we got, actually. And it is, if the police have me and they're interviewing me, do I have to talk to them? Do I have to answer their question? I think most lawyers would know this, and I think that you're going to give us a good answer. But go ahead, Abe. Do you have to answer questions the police are asking you?
You do not have to answer the questions the police ask you. In fact, it is your right not to do so. And so that's called your Fifth Amendment right, not to self-incriminate yourself. And they give you a nice little Miranda warning before they instigate trying to investigate. And we've all heard it before. Brad?
Yeah, sure. You have the right to remain silly. Do not answer any police questions. No, we all know you have the right to remain silent. Anything you say can and will be used against the court of law. If you can't afford an attorney, one will be provided for you. That's basically it. In Lexington, they actually go a little bit further, and they say, you can stop questioning at any time. If you'd like, by just asking for an attorney. Well, they go a little bit further than is actually required. At least most of the time they do, in my experience. Would you agree with that?
Agreed. Yeah.
And do you think that there's ever a time that people should talk to the police?
Not without their attorney, no.
Yeah, I agree with that, actually. Yeah, there may be a time that you should talk to the police, but there's never a time you should talk to the police without having an attorney present. I would agree with that. So let's kind of switch over and see if we've got another question that came in. I know we've got a lot of them. Anybody out there have any questions, please don't hesitate. So the next question I got, and I get this a lot, is what is an arraignment? You want to go ahead and answer that one for us?
Sure. So your arraignment is your first court appearance in front of the judge. It's for the judge to formally announce the charges against you, and so you understand them, and at that point an attorney attaches. You have a right to an attorney at that point. And what your attorney will normally do is plead not guilty at that first appearance. They'll schedule a new court date, which is, depending on what court you're on, it'll either be called a pretrial, a status conference, a review hearing, and you may ask for discovery at that point, which is evidence in the case, and at that you will also get, if the client is still in jail, you'll ask for a bond reduction at that time.
Okay, great. Do you want to ask me maybe a question? Give yourself a little bit of a break. I mean, is there anything you see in there that you think that I would want to answer, or maybe you can you want to try to stomp me? I hope. I
don't think I'm going to do that, but
you put me on the spot with the Miranda warnings.
There you go. If the individual who called the police or pursued charges does not want to go to court, will my charges be dropped automatically?
Well, that was going to be a tough question until you said automatically. And the answer is no. A lot of times, you'll hear people say, well, this is a Commonwealth state. The Commonwealth picked it up. That's not exactly right. What it is in the criminal justice system, there are two parties. There is the defendant, and then there is the Commonwealth of Kentucky. If, for instance, Abe over here, reared back and punched me in the face, and then he got charged criminally for that, it wouldn't be me against Abe. It's society against you. It's the state of Kentucky against you. And so what that really means is, at least in this context, is that it's not just up to Abe whether or not the case gets dropped. He could, or me, I should say, in that case. Even if I said, you know what, Abe's a good friend of mine, I don't think that he should go to jail, that's not my call necessarily. Now, we're moving to a society that's more and more in favor of the victims having a bigger say in the process. We just had this big issue with Marcy's Law back in November. That's this constitutional amendment in Kentucky that they voted for. We voted for. I didn't vote for it, but people have voted for, that would give victims more rights. And we may be seeing that this gets to be more of a question where the victim does have some more say in the process. Now, most prosecutors, and all good prosecutors, do take that into consideration. What are the interests of justice, both for society and for the victim? It's a tough job being a prosecutor because you're balancing a huge workload. You've got somebody coming to you and saying, hey, this guy punched me, but I don't care anymore. I'm not going to cooperate. And how do you weigh that? I don't know. I mean, my heart goes out to prosecutors every day. They're especially dealing with domestic violence cases. I know that's hard. And but at the end of the day, it's up to the prosecutor to make that decision. It's not up to the person that's the victim. And so, no, just because a person you got in a fight with decides they want to drop it doesn't mean it gets dropped.
Go one step further, in that prosecutors, they have the power of the subpoena. And so even if a victim says that they don't want to cooperate, they don't want to come to court, they don't want to talk about the case anymore, they want it dropped, the prosecutor can find them, issue them a subpoena, and hold the subpoena power and make them come to the trial. And if what I've seen happen a lot is they can say, well, if you don't testify truthfully, we're going to charge you with perjury. And so if they really want to pursue the action, it, like you said, it's not victim versus defendant. It is the Commonwealth of Kentucky versus defendant. And so I've seen prosecutors try to use that power to go forward with the charges. Maybe they feel strongly about it. Maybe it's a situation where it's happened multiple times in the past, and they want to stop it. And so I would say that.
Okay. Yeah, no, I think that's well taken. Next question we got coming in was, what is the difference between a felony and a misdemeanor?
So a felony is a charge that is punishable by a year or over, whereas a misdemeanor is punishable by up to a year, so anything less than a year.
Okay, and I guess to go a little bit further into that, I think that the major distinction is a misdemeanor is what we would think of as being potentially a minor crime, but it isn't necessarily. For instance, like assault 4th degree, which is assault with a non-deadly weapon or without a weapon that doesn't lead to any serious physical injuries, an assault in the 4th degree. And so, I mean, punching somebody in the face, is it serious? Is it not? I mean, I think it's on a spectrum of crimes. It's not as serious as murder, obviously, but it's more serious than littering. And so a lot of people don't understand that some misdemeanors are, can be pretty serious. It carries up to 12 months in jail. It should be serious, but other misdemeanors are kind of less serious. Like, I mean, not that I support littering, but as an example, littering or disorderly conduct, public intoxication, which can also be a violation, meaning it's only punishable by up to a fine. Possession of marijuana is still a misdemeanor for now. It carries up to 45 days in jail, which is crazy. And if anybody out there is representing defendants and the prosecutor offers them 45 days in jail or on probation or anything on a marijuana case, I encourage you to take the case to trial. The people of Kentucky are getting ready to speak on this. I think we're going to see some movement out in the legislature next year, if not in the coming years. And it's just, you talk to people on the streets, they're so sick of people being put in jail for minor drug offenses, particularly marijuana. And I think that we as a society are ready to move on. But in any event, felonies are divided into 5 types. Okay, there's a Class D felony, a Class C felony, a Class B felony, a Class A felony, and then there are what are called capital crimes in the state of Kentucky. And a capital crime is a crime which is punishable by death. A Class A felony is a felony that's punishable by 20 to 50 years or life. A Class B felony is punishable by 10 to 20 years, and a Class C felony is punishable by 5 to 10, and a Class D felony is punishable by 1 to 5. Some Class D felonies are removable from your record through a process called expungement.
You don't know anything about expungements, do you?
I've been told I do. But many of them are not, and almost every felony but for those Class D felonies is going to stay on your record for life. It's going to follow you around. You're going to have to check that box when you apply for a job. You're not going to be eligible for certain types of housing, certain types of student loans. You are not going to be able to possess a firearm or even vote in the state of Kentucky until the governor gives you what's called a partial pardon. We're one of only 2 states that still permanently disenfranchises felons. And I think that might change too. I hope so next year. We're going to be making a big push, the group that I'm a part of, the Kentucky Association of Criminal Defense Lawyers, and you are too. We're both board members. I'm actually the vice president. We're going to be making some real efforts at the legislature to get this changed, to get some action here, because I think it's ridiculous that people can make a mistake when they're young and not be able to vote for the rest of their life. That's just crazy. So, Abe, I'm going to move on. Let's see. You have any other questions that you've got come in yet?
Sure. What does it mean to vacate a conviction, and how do you get a conviction vacated?
Okay, well, that sounds a good question for me to kind of follow up on that. So in Kentucky, we use different types of language. We don't necessarily say vacate. That's kind of what happens on appeal. If a judgment is found to be erroneous for some reason, it can be vacated on appeal. Really, the language we use is expungement or voided. They're 2 different things. Voided and sealing is one thing, and expunging is another, though at this point, they're pretty much treated the same. And by an expungement, certain crimes, most misdemeanors, some Class D felonies, and sometimes cases that are dismissed are eligible to be expunged. And what an expungement is an order from the court saying that this didn't ever happen. The person that was convicted can then, after going through certain process, say truthfully, at least on almost all applications, though not necessarily in the context of the federal government and certain licensing boards. You should talk to your lawyer if you've had an expungement before you answer questions about the conviction. But ultimately, that person can then be relieved from the judgment. It shouldn't show up in legal background checks, meaning background checks that comply with the Fair Credit Reporting Act. It's a federal law. It may still show up in some online mugshot searches. It'll still show up if people have outdated databases. But ultimately, it kind of it undoes the process, and it's something that's very valuable. So I could talk about this for hours. I have talked about it for hours. I've trained lawyers on this. I've trained common people on this. I've trained everyday people, regular non-lawyers, I should say, on this. And it's gotten more and more. There's a greater and greater body of law. We're still trying to interpret what all is actually eligible, but we're making a lot of progress on it, and I think that there's a bill that's been pre-filed for the legislature in January, February that is a great bill that would fix a lot of the loopholes. I look forward to seeing it pass. I can't recall whose bill it is, but I think it's a great bill, and if it passes, a lot of people are going to get a lot of help. It would add some offenses that are felonies that are eligible, and it would fix some of the loopholes with misdemeanors and dismissed cases. So be on the lookout for that if you haven't been able to expunge something in the past and you'd like to in the future.
Sure.
All right, Abe, what else we got?
How long does a bench warrant last?
Do you want to answer that one?
Sure. The easy answer is forever. It's not going to go away. I've actually handled a few cases. I'm handling one right now from a warrant that was from the mid-'80s. And so it was prior to the theft laws changing. And so we're dealing with a theft of over $300 instead of now it's over $500 with the current law. And so you can, if you have a bench warrant, it's best to call your attorney and try to get that resolved as quick as possible.
Yeah, no, I think that's well taken. And I've seen that too. People get picked up on a warrant that's 50 years old almost. It's crazy. We went to this system, I think it was in the early 2000s, called e-warrants, maybe late 2000s. And it really brought a lot of the old warrants back to the forefront that are still out there that just haven't been served. So if you think you might have an old warrant, then you, a little technical difficulty, but then you may want to look into it. Hire a lawyer to look into it. They can find out if you have a warrant in most places, not everywhere, but in most places, and they will be able to help you. I think that answers that. You got any?
Sure.
What else you got?
Do I still need a lawyer if I plan on pleading guilty?
Yes. Yes, you still need a lawyer if you plan on pleading guilty. Yeah, let me take this one. So there are so many different ways a lawyer can help you, even if you plan on pleading guilty. And that just starts at getting the sentence reduced. So many people are charged with everything they possibly can be charged with. I've seen people charged with hundreds of counts of felonies. And it's just absurd. To think that someone... If one person can go out in a week commit 100 and 200 felonies, then we maybe need to look at the laws. But ultimately, prosecutors do exercise discretion. They don't have them plead to all of them. And what good lawyering can do is, even when you're completely guilty, you're on video, holding up your Social Security card, saying, "Hey, I did this," and you here I am with my distinctive tattoo. My name is Abe Mashney. I've got 4 tattoos, the Baldani Law Group logo on me. I did this. Here's a video of it live on Facebook. You still can have a lawyer come in and say, well, Abe he's been going through a lot at work. He's mentally ill. No, but in all candor, lawyers can help mitigate punishment. They can help mitigate penalties. Yes, thank you. Somebody just liked us. The counter went up, so everybody that saw that is pretty cool. You can make that happen at home. So, the next kind of thing that lawyers can do is they can help get you a different kind of sentence, right? Because prosecutor may recommend a certain number, but the judge may have the decision or the discretion to decide if that's probated. Are you put on supervised probation? What are the conditions? Is it unsupervised probation? And that can make a huge difference versus going to prison. And I think that you would be remiss if you did not hire a lawyer to help you with that. And also, lawyers can just help you understand the process better. What am I signing up for when I agree to this? Even if it's pleading guilty to disorderly conduct because you got drunk at the St. Patrick's Day parade. By the way, go ahead and block it off in your calendar. Baldani Law Group has something very special planned for St. Patrick's Day this year. You should be at the downtown Lexington St. Patrick's Day Festival, but I'll leave it at that. Nonetheless, even if it's something minor, this can follow you for a long time. A DUI is going to stay on your record for 10 years, you know. Some enhanceable offenses, even like selling a small level of marijuana, potentially could stay on your record forever. Misdemeanor marijuana trafficking may stay on your record forever. We don't know, but with the way the law's written. But right now, I've got a case at the Court of Appeals on it. You know, so just very small things could really follow you around for a long time. Don't jump into it without a lawyer. You really need to talk to a lawyer. Abe, do you have anything to add on that one?
Sure. I mean, I can think of just 5 reasons alone, just on DUI cases, that a lawyer itself can help you out with instead of representing yourself. So even if you were the drunkest person ever, driving in a car, got pulled over and arrested for a DUI, and if you want to just plead guilty immediately, here's the things that a lawyer can help you out with. 1, it can ask for home incarceration. I can guarantee you that the average Joe that is walking in the courtroom intending to plead guilty doesn't know about home incarceration. The second thing is walk you through the process. And so the courthouse is big. It's complicated. There's several rooms. They don't do a very good job of labeling where to go. There's nobody that's going to hold your hand and walk you to the home incarceration office, or to show you where to pay the fine, or anything like that. So we are here to help you and make the process as smooth and easy and make the best of a difficult situation. Third, interlock device. A lot of people are so surprised, even though the law's been out for 2 years now, as far as getting that device on your car.
Yeah.
People think, oh, well, I have to have my license suspended. That's just how it works. Well, it's not how it works anymore.
Not anymore.
And so we can make it to where, assuming that you're eligible, that you have you lose your license for a day, maybe 2 at most.
Sometimes longer, just depending on when it falls. Like if you play guilty on Friday, you're probably not getting an interlock till Monday or Tuesday. But
right.
Yeah,
and so you're talking about days instead of months. We'll hook you up with our providers. We will walk you through the process, file the paperwork, get the judge to sign it, tell you exactly where to go, what to do, and have an interlock device and new license on your car as quick as possible. So you're back on the road, so you can go to work, you can take care of your family, and do what you need to do. The fourth thing is there are a litany of procedures that the government has to do in order to obtain evidence correctly. An attorney can look at those. We can see if there's any procedural deficiencies in there, challenge those, and it may be that they obtain the evidence wrong, or it may be that the officer screwed up. You never know. And so you're at least giving yourself a chance in order to fight the charges instead of just pleading guilty to begin with. And then finally, there's multiple, they're called ADE classes. If you plead guilty to a DUI in Kentucky, you have to do those alcohol driver education classes, and your attorney can show you the list, help you get signed up, and answer any questions, because we have relationships with a lot of them, and you can help them with that process as well.
Okay, we've got about 10 minutes left. If anybody out there has any questions, now is the time to send it in. And more importantly, or maybe equally importantly, if you haven't gone to the Baldani Law Group page on Facebook and liked us, you can like us and you can watch this thing, click up one. It's incredible. So 10 minutes left. Send in your questions. If you haven't already, in a different tab or in a different browser, or maybe when this is over, go and like us so the count goes up. We're trying to hit 1,500 before the year's over, and we can only do it with your help and about another 140 people. So in any event, Abe, let's move on. What other question did we have come in?
All right. So the next question is, what is the difference between probation and parole?
Okay, I'll take this one.
Sure.
So the difference between probation and parole is really the terms and how it works and when you serve it. Probation is a sentence that is probated, that is suspended, we should say, before you go to prison. And so imagine you get out on bond and you enter a plea, and part of the terms of that are you're going to be probated for a period of 5 years. You'll have 5 years over your head for 5 years, meaning you'll have a 5-year sentence that is going to be suspended for 5 years for good behavior. If you violate or pick up any new charges or don't meet with your probation officer, if you abscond, you test positive on a drug test, you can receive a warrant for what's called a probation violation. At that hearing, the judge will make a decision on whether or not either to revoke you or to reinstate you, or maybe to partially revoke you, give you a sanction, give you a penalty, make you go to jail for a weekend or so. important to know about probation is the amount of time you're going to be on probation is determined at the outset. Like I said, 5 years probated for 5 years. Parole is something that occurs on the other end. Now, probation and parole are both kind of creatures of the Department of Corrections. They're both supervised by the Probation and Parole Office. It may even be the same officer you had for probation would be the same as your parole officer. It does happen. And what parole is if you're sent down to serve a sentence at prison, after a certain amount of time you become eligible for what's called parole. Parole is a different type of suspended sentence. It is, you've already been to prison, thank you, and at that point the parole board has decided to show you leniency by releasing you. And what that means is you get out on the streets. Now, one of the differences with parole versus probation is it is determined by how long you were serving it. So you're going to get day-for-day credit while you're serving your parole. You're still going to go meet with the parole officer. You're still going to go meet drug tests. You're still going to have maybe classes or things like that, different things you have to follow, although in my understanding is it's a little bit less supervision on parole than it is probation in general. But ultimately, it's about when you serve the sentence. Parole is a form of leniency. Probation is a form of alternative sentence. Abe, do you have anything to add to that?
No, but we do have our first question.
All right, what is it?
So this question is, if I am charged with a crime and want to hire an attorney, what should I do to prepare for that initial meeting with the attorney? What questions should I ask the attorney to make sure that I have a competent counsel for my case?
Okay, I think that's a great question, and I'd like to thank whoever gave us, or should we? I mean, I guess it's public. Who gave us that?
Karima.
Thanks, Karima. What I would say is a number of things. The first thing you want to do is go online and see who is this guy, who is this girl, whoever it is. If they've got a web presence, do they know what they're talking about? Are they the kind of lawyer that does the work that I need help with, right? Like, you may not want to hire the same lawyer for your DUI and your murder case unless it's me. And then, but no, I mean, you just certainly don't want to hire the same lawyer to probate a will that you probably would want to hire for your murder case, right? They're just two distinct things. And so ultimately you're going to want to look first, hey, does this lawyer practice this specific area? In rural areas, it may be harder to find people that are as niche as you would find in an urban area, but at the same time, people are going to have reputations for, they go to trial, they do criminal cases, they do personal injury cases, whatever it may be. So you're going to want to find somebody that has experience doing the work. Now, that doesn't mean they have to be 50 years old. It doesn't mean they have to be 40 or 30 years old even. Well, maybe for the most part it's tough to get a lot of experience before you're 30. But nonetheless, I mean, somebody that's gone out there and has done those cases, like I know as my prior experience as a public defender, I was trying murder cases on my 30th birthday. You know, I was handling capital cases as lead counsel on my 31st birthday. So it just depends on who the attorney is and what their experience is. That said, what I want to do to prepare is, well, I want to get every document I've got about the case. I want to bring that to them. If I have any history of mental health treatment, I want to go ahead and start getting my medical records. You know, I want to show them, hey, you know, this may explain or mitigate what happened. If I've got any physical damage, right? Say I got into a fight, I might want to find pictures of defensive wounds, right, where the other guy hit me to kind of prove my self-defense case. I want to take pictures of myself to prove that because, you know, the wounds heal, evidence dissipates. And so you want to get all that done.
Screenshots of text messages.
Screenshots, text messages, phone records, whatever. And bring all that in for the initial consult. And if the lawyer's serious about taking the case, what you're going to find is that lawyer is going to look at it, and he may not be able to give you a perfect opinion, but you're going to get a lot more information about what their thought process is, what types of defenses they want to put on. And I think the questions you want to ask are, you know, have you ever had a case like this? What was the outcome in that case? And even if it's a tough case, I mean, I'm not saying you should expect them to say I've had a case exactly like it and I've won it, but if they can say, well, I had this case, it was kind of like it, this is how it came out, or this is, you know, even if they say, you know, this was a tough case and this is what we ultimately did, I think you're going to find that they're going to either know immediately if they've had a case like it, or they're going to be, or they can be honest about it. And sometimes, you know, I've had people come to me with things that I've never done before. We did a Title IX hearing earlier this year, which is has to do with sex assault on campus. You know, somebody getting kicked off campus, but I was able to get into it because I'd done sexual assault cases in the criminal system before. And they trusted me, and we got a good outcome. But ultimately, I think you're going to want to find somebody that's got the experience, that they can represent you, right? I mean, it's got to be somebody that you find, thank you, by the way, personally appealing, or that can, you know, you get along with, because this is going to be one of the most stressful things you ever go through.
I think that's extremely important. You got to feel comfortable with them.
You got to feel comfortable. You want to get somebody you can approach with something that you're very nervous about. I don't know, Abe, what do you got for us?
Well, going back on comfortable, I mean, you all are, the attorney and the client are battling. It's a battle. And so they have to open up to you. They have to feel comfortable talking to you, being honest with you, talking about what happened and what your goals are, because every case is different and every case is going to have different goals. And so you're going to need to feel comfortable calling them, asking them honest questions. And then you have to trust them, because it's got to have a trusting relationship, to trust their advice. And do you feel comfortable with the advice that they're going to ultimately give you? I think it's important to note, are you hiring a legal team? Are you hiring a solo attorney? Are you hiring a big firm? What are you looking for in representation? I think there's plenty of good attorneys down Short Street here in Lexington, and there's different people with different backgrounds. We do a team approach. We think it works. If one person has a better experience with a prosecutor, a judge, or more experience on a specific type of case, they'll be the lead person on that case. And so we also like to work together. If we don't like to recreate the wheel. And so if something's worked in the past that one of us has done, we'll routinely say, here you go, this is going to go in the bank, and we're going to use that to the client's benefit.
Okay, well, we're about done. We've been going for almost 30 minutes, I think. I want to thank everybody that watched. I definitely want to thank everybody that hit like. I don't want to thank Brent Cox, who asked a stupid question. No, there are no stupid questions, Brent. We love you. But I'd like to give a shout-out to everybody that watched, Karima, John Hain, Don Kaiser, everybody else that's out there. Really appreciate you guys watching. We love doing this. We love your support. We love answering these questions. If you guys have any questions in the future, just put them at the bottom of this one, and we'll see it, or send them to me in a direct message, or post them on the Baldani Law Group page. We'll answer them. We're planning on doing this at least once a week. Like I said, get out there, like, comment, whatever it is. If you want to be on the show, Brent, come on. Just let us know. We'll get you on the show.
There we go.
Yep, one more. All right. Anything else, Abe?
That's it.
All right, let's rock them out. Thanks, y'all. Peace.